so much for joining us for another episode of the Elder Law Out Loud podcast. We are so excited that you're here with us today because we're talking about a really important topic. Today, we're talking about what happens if your loved one passes away without an estate plan in place.
Yeah.
And unfortunately, we deal with this a lot here at Family First Firm. I'm here with the founding attorney and CEO, Jeff Hotzen, to talk a little bit more about this. And when someone does not have an estate plan in place at the time of their passing, what happens? It's a bit of a mess for family.
It can be. So the interesting thing, what I like to tell people is that, I'll say, hey, who here has an estate plan? And some people raise their hand, like when I do seminars and things like that. And I always say, well, every hand should go up because even if you haven't created your own estate plan, the state of Florida has done that for you. So there's actually in our statutes, they have decided if you don't have a will, if you don't have a trust, they decide what's going to happen. So it may not be what you want to happen, but everybody actually has an estate plan in the sense that, that there is a backup plan in the case that you don't do this before you pass away. Unfortunately, I've read a statistic that says that over 50% of adults in America do not have a will. So most people put this stuff off. Everyone thinks they're going to die at 120, so they have until they're 119 to
Right.
get their will together, and then God forbid something happens earlier, which statistically is very likely. And then their families up a creek without a paddle. So what happens if you don't have anything in place and you're relying on the state of Florida to decide where your stuff goes? Well, you're going through a process called probate. Now, I know the first thought people are going to have is, well, hang on a second. When my mom passed away, my dad didn't have to go through probate.
Right.
That's always well, so that obviously that isn't true. And they have a great point. Very frequently you have a married couple, they jointly own everything together. One of them passes away. When they're married, it's presumed to be what's called with right of survivorship. It's tenants by the entirety. These are terms that we could talk about maybe on a different podcast because I don't think they're relevant to this, but ultimately it means that it automatically goes to the survivor. That only happens with married couples, though. And so if you don't have that, then you're going through this estate administration process called probate.
Okay. And probate, for somebody who has never experienced this before, it's a court process.
Right. So it's a court process that when you pass away, if you haven't done any planning, you file this court case against yourself with your own money for the benefit of your creditors. That's a real negative way of thinking about it, but that's truly what it is. That is like the point of probate. Essentially, it is to ensure that your stuff goes to the people it's supposed to go to. But your creditors get to show up first when you pass away, and they're entitled to be paid whatever they're owed, and whatever's left at the end that goes to your kids or your spouse or whoever.
So if I'm a child of someone I know has debts, why would I even go through the probate process?
Because you can't get your inheritance without going through it. That's the other piece of it. So in order for those assets to go from your parent to you, you have to go through this court process and have a judge oversee, make sure that the creditors are paid off, and then make sure that you're actually the person who's entitled to inherit. Because there's a lot of situations where you may have we've seen it with, I think, significant more frequency just this year, but neighbors wanting to file probate for their friend who, lived next to them and, didn't have any family and they helped and took care of them and everything. And they want to file a probate and try to inherit what that person left. It doesn't work that way.
Right. Everybody would do that if that were the case.
Exactly, exactly. So the state of Florida says, hey, we're going to look for any potential relatives that you may have had ever. You know, so if you don't have children, if you don't have, parents still, if you don't even have brothers or sisters, we're gonna go up to your grandparents, see if we can find cousins. If they're dead, we're gonna go down and look for nieces and nephews and all that stuff. And that's why occasionally you hear people saying like, "Hey, I got an inheritance from this uncle I didn't even know I have,"
Right.
or this, it's because that uncle didn't have an estate plan in place. It had to rely on the statutes, the laws in the state where they lived, and now all of a sudden it's going out to someone that they've never met.
Okay, so whose responsibility is it to enact the probate process and start looking for those heirs, start, looking for the accounts that may exist? How does that all work?
Great question. And it's kind of a weird answer because nobody is required to do it. And anybody who is a resident of the state of Florida and is an interested party has the ability to do it. So I can give you examples. There's been circumstances where there have been people, sometimes even attorneys, who have served as personal representative to open a probate. Personal representative is the executor. So, executor is a very common term that people are familiar with. Personal representative, not so much. It's a kind of a Florida unique term that we use here. But ultimately, um, anybody who feels like they have an interest in this can actually petition to be appointed as the executor. And there is, I will say, there is a priority of appointment. So the statutes, our laws would say, okay, if you have children, they're going to have priority. If you have siblings, you don't have, it's going to go there first before they just allow a stranger to be
Sure.
appointed. But really, anybody who feels like they have interest in this, it can even be creditors, can open the probate process to start that probate proceeding so that they can make sure that they're paid. And the reason they might do that, because people say, hey, why would a creditor bother opening? Well, their claims are barred after 2 years. So if you don't move forward on the probate, um, then in theory, sometimes we counsel our clients to do this.
Just wait a little bit.
Just wait.
Wait it out.
Yeah, if there's substantial creditors, wait, because the creditors are unlikely to do anything. And at the end of 2 years, they can't come back.
That's really interesting.
Yeah.
That's a good pro tip you just got here from the
Hmm.
podcast. Um, in my previous job, reporting on issues with probate,
Right.
I have seen long lost relatives come out of the woodwork and file petition to be that person in charge, ending up, getting in control of properties and accounts that probably shouldn't have gone to them. So, what are the checks and balances?
I mean, again, I hate to sound like a broken record. It kind of goes back to the statutes. So, the fortunate thing about the probate process is there is a judge that oversees it. So, just because someone's appointed the executor, it doesn't mean that they can just do whatever they want. They don't get to decide who inherits. The judge decides that. And so the judge is going to say, hey, you have to pay off the creditors exist. So the way that he finds out is creditors actually place claims in the probate process. So they file in the court case. People say, well, how would they know? You're required to actually any creditors that you know of, you have to send them notice. So you send them something in the mail saying, hey, this person passed away. We've opened a probate. We think you might be a creditor. You're welcome to file a claim. For those that we don't know about, we file a notice in the paper. And so there's a notice every probably not every newspaper, but I think most newspapers have the option where there's like a announcements, if you will, section, and in that section we post these notice to creditors, and they run for a few weeks, and then creditors have 3 months to come back and place a claim after that's run. Once that 3 month window is done, then those creditor claims are barred at that point too. So that's also another way to shorten that 2 year period. The problem is you're putting everybody on notice.
Yeah.
But, and I think I've gotten off track a little bit to your initial question, but bringing it back. So, the judge makes sure those creditors are paid, and then he's going to look to the statutes to determine who's entitled to inherit what's left. Now, the person who serves as the executor is entitled to be paid for their services, as is their attorney, and that comes off the top. So sometimes you'll have people fighting about being the executor because they know that they're going to get more money for serving. Now, in my opinion, you're getting paid to work. It's not,
Yeah.
it's not, it's not like you're not doing anything. So it's like, oh, you want another job and you're going to be paid to do that job? Cool, good for you.
Yeah. Is there a formula that says how much they can get paid through the probate process?
3%. That's the
Okay.
statutory rate. That's also the statutory rate for their attorney.
Okay.
So, it does have some, it's a little more nuanced than that, but that's a good, I would say, general idea. If the estates get really large, that percentage comes down a bit. If it's a little bit lower, they're talking just dollar figures rather than percentages. But I'd say for probably 95% of probates, it's going to be 3% of what's there. And that's the rate that the Florida statute sets as what they define as a reasonable rate for probate.
Okay. So if someone passes and they own a home property and the property is vacant at the time of their passing, what can the heirs do with that property before the probate process is finished? Can they do anything to the home?
Great question. So I think the answer is going to depend in a couple different directions, or let me rephrase that. The answer is going to depend on the answer to this question, which is the house probate? I mean, homestead or not? Was it the person who passed away? Was it their homestead property?
Sure, for the
Okay. So
purposes of this
sure, for the
conversation, we'll
purpose of
say
this
yes.
conversation, then it becomes a lot dicier as far as what they can do because technically homestead property in the state of Florida is not a probatable asset. As long as it's going to somebody who's entitled to homestead protection, really what that means is lineal heirs of the decedent. So, um, if that person is, I should say, if whoever's inheriting are entitled to that homestead protection, it is not considered a probate asset, which means it's not subject to uh, uh, creditor claims. It's not subject to any sort of actually probate proceedings. Basically, what it's almost like an extra probate, like outside the probate asset. It's weird because you have to deal with it through probate, and through the probate, you petition to have the court say, "Hey, this is exempt homestead property." And we're gonna issue an order directing that it goes to somebody, whoever's entitled to receive it. But it actually isn't part of the probate process, which makes it a little weird because that's where you run into things where people are like, okay, there's a mortgage on it, there are bills, there's taxes, um, and there's you have to pay utilities. So how does what happens with that? And the problem is in those situations you can't actually use probate assets to do it, or if you do, you need to like create a lien then on that property. It gets a little sticky
To be
if it
paid back once the
to be
probate
paid back
process is
once
done.
yeah once it's done or once the home sells. Um, the flip side of that is if it isn't homestead, then it becomes a lot easier. And then the personal representative will generally have to petition the court to approve any sort of outlay of probate assets to maintain that property. But it's generally within their rights to do that and ultimately, it's a little bit easier to maintain that property. Our homestead laws in Florida are very unique. We're one of, I think it's us in Texas have complete unlimited homestead protection from creditors. If you go one state north to Georgia, I think they only exempt like $10,000 of your house's value from probate, which means that if you pass away and you had any creditors, they could take your home.
Wow.
That doesn't happen in Florida, which is great. It's good for us and good for our citizens who live here. But it does create a little bit of stickiness in the probate process after people pass away.
So if someone passes and it is a homesteaded property, just to clarify, the heirs can move forward with the sale of the home, or do they have to have a court order saying this is, you're the rightful heir to this property?
Great question. I think that's what you're asking me. And I misunderstood it. So as far as selling a home, with homestead property, because it's not part of the probate, it actually doesn't have to wait until the probate is done. There's some caveats to that. Um, if you're assuming a normal formal administration, which takes like 8 to 12 months, you could have an order entered directing that the homestead property is transferred to the beneficiaries in like month 4, 5, or 6. So in theory, at that point, they can sell the property. Sometimes we're doing what's called a summary administration, which is a much abbreviated sort of probate proceeding, and that gets the homestead order will be entered at the same time that that probate's closed. So in those sorts of situations where maybe there's only a home, you would have to wait until until the probate's closed in order to sell the home.
Okay.
Now we will regularly see people who are listing the home, but listed with the understanding that, hey, it is in probate and it will not be able to be sold until this probate is done.
Okay.
So, sometimes we're working with people like, oh, we want to list it because we want to start getting, attention. Cool, great. You can do that, but understand you're going under contract knowing that it's not going to sell until this probate's done.
Can't close until
Yeah.
the other process is closed.
Hmm.
So we talked about homes. What happens to bank accounts? The creditors get first crack at that?
That's right.
Okay. So the goal is to die with no debt.
Right. That's a goal. Yeah.
Die with no debt and have the homestead on your property to make it easier on your heirs.
Yeah.
In Florida, you have to hire an attorney to do the probate process. Can you talk about why that is?
Yeah, it's very complicated. And there are multiple interests in this. And what I mean by that is, let's use an example of somebody who passes away, they have 10 kids. The youngest is a bit of a rapscallion, probably, trying to maybe get one up on their non-siblings. Um, you can imagine a situation where like things wouldn't go well if they're left to their own devices and they're found with the court alleged that, oh, they're the only child. And so they're asking the court to give everything to them. They get a court order, they get it all, and they skip town, right? Um,
Does that happen?
well, no, because lawyers have to be involved. And we have both ethical and, fiduciary responsibilities. Ultimately, our job is to make sure that our clients are doing the right thing. We can't force them to, but if they're not doing the right thing, we can withdraw.
Mhm.
And since they
We're
have
not
been
we're
our
not defense attorneys around
right,
here.
exactly, yes, yes, not at all. But ultimately, and we've had to do that in some cases, say, hey, you're not doing what we're telling you to do, so we're no longer going to represent you. And you're going to have to find another attorney. But you're going to have to find an attorney. For them, if they want to do something underhanded, they're going to have to find an attorney that cares more about that one case than they do about their bar license.
Mm.
And there's not a lot of those people out there. So in those situations, we found that the requirement of having an attorney really prevents some of those kind of nefarious things from happening. Also, it is a really complicated process, and it's not something that an average person would really do well the first time. So, having somebody who does it day in and day out really speeds things along, makes things a lot smoother for the courts.
Now, we get oftentimes clients who will call us who maybe live in another state, but they have a loved one who had property here in Florida and they're trying to navigate the process. This is different from state to state. It's
Wildly.
not one size fits all, so that makes it even more
It
complicated.
does, yeah. So each state's different. They have their own requirements and rules. In some states, it's a lot quicker. In some states, it's a lot longer. You know, um, there's a number of things that can play into that. But how their process is set up, also the amount that the state spends on their judiciary, right? The more judges you have, the fewer cases they have, the quicker things move. If you have fewer judges, because maybe your state, like the state of Florida did a number of years ago, cut funding to the judiciary, all of a sudden everything took really long.
Mhm.
And I think they may have made some efforts to try to push more funding back towards the judiciary to get more judges on the bench. But ultimately, those are some things that can really cause the timelines to vary wildly, I would say. Um, yeah.
So the goal to avoid probate, obviously to have an estate plan in place is number one.
Yeah,
But there are things that people can do on their
of
own
course.
to minimize the hurt at
Sure.
the end of this process. Can you
Yeah.
talk a little bit about that?
Yeah, so I'll use an example. I just had a call less than an hour ago with a family. Their brother, who didn't have any children, he had come to us to do some estate planning. He said he didn't want his sisters to have to go through the probate process. He had a home and two bank accounts, and that's it. We gave him the advice. We said, hey, we can set up a beneficiary deed. We call it a ladybird deed on your homestead property, so it will automatically go to your sisters when you pass away. And for those two bank accounts, you can go to the bank and name transfer on death or payable on death beneficiaries to your two sisters. So whatever's left in there when you pass away will automatically go to them. They just need to show up with a death certificate. So um, they called us asking if he did that with the bank, and I said, well, the bank didn't tell us, and
Yeah.
obviously they wouldn't. So we don't know. I can tell you that we put the deed, and it's recorded, and so all you need is a death certificate to file with the county, and that home is
Yeah.
yours. But we just have to wait for, you're going to have to take the death certificate over to the bank in order to.
And this
Figure
client,
out.
this client passed.
He passed away.
Yeah.
Yeah. So he passed away last month, and as a result, his sisters were trying to figure out what they do to make things a little bit more challenging. I think their ages were 97 and 94, so not exactly super mobile, excited to be
Yeah.
running around town doing some of these things, but you know it it ultimately will save them a bunch of time, and it'll even running around town. It's going to be a lot easier than say hiring us to take them through an 8-month probate process.
Right.
So those are the types of things people can do. They can name beneficiaries on their accounts. They can put ladybird deeds on real estate that they own. We do that regularly. The only downside of doing that is it doesn't really account for changes in your life.
Okay.
So hypothetically, let's say you have two kids and they have children of their own, and one of your kids would predecease you, and you don't update anything. Well, it's just going to the other child. A lot of people would say, hey, I want to split 50-50 along the family line. So if one of my children were to predecease, I want their share to go to their kids rather than their kids, my grandchildren on this side missing out on that inheritance from me because their parent passed away first. So, you know, while the beneficiary designations are good, they're definitely not a panacea. Like it's not a cure all, works for everybody all the time. There are a lot of situations where they fail. But It is something that anybody could do on their own to try to make sure that their loved ones don't need probate.
And then if you are named as a beneficiary, you get access to those accounts upon your loved one's passing.
Yep.
What if your loved one had creditors? Can they come after you?
No.
Okay.
So that's the cool thing in Florida. The creditors are limited to the probate estate. So if
So as
everything,
long as you move that money quickly.
Yeah. Well,
yeah, I mean, but believe it or not, it doesn't even matter how quickly you do it. As long as there's a beneficiary on it, it does not have to go through probate. There could be $10 million of creditor claims in a probate process. And if all the accounts have beneficiaries designated, you could wait 2, 5 years. Well, it doesn't make a difference. And whenever you take the death certificate down there, that bank is going to write you the check and your creditors are up a creek.
Okay. So you want to,
Make those actions prior to a creditor making a claim on an estate.
Yeah, I mean, so a creditor isn't going to make a claim until you passed away, and you can't name beneficiaries after you're dead, right? So you name them while you're alive, and then that ensures the creditors don't have any access to that after you pass.
okay.
So that's a life hack for
Yeah.
avoiding the probate process.
Yep.
And obviously, estate planning as a whole is most recommended because it takes into account not just bank accounts, homes, things like that, but really gets into the nitty-gritty details of how you want your last wishes to be carried out.
Exactly. As a just brief example, what my wife and I have done for our kids and we set up a trust. But what we've done is we've said, hey, if we pass away while our kids are little, we don't want them just getting the money, right? They couldn't get it anyways if they're under the age of 18. But we've named a trustee who's going to use that money for them. And even when they reach the age of 18, they're still not getting it. Now, that trustee can use it to pay for college, can help them, maybe pay for a wedding, down payment on a house, help them start a business, purchase a car. I always say this is the Honda, not a Maserati kind of thing. So the trustee is able to use those funds for them in ways that will kind of protect them from themselves, maybe, and protect them from the people around them. But then when they reach the age of 25, they get a third of whatever's in there. Now, they're probably going to screw it up. They're probably going to blow it in 6 months or something. I hope not, but
We're all young and dumb at
That's
some
right.
point.
And so that's why we only did a third, because then from 25 to 30, the trustee can still use it for them, all those same things. When they get to 30, they get half of whatever's left in there at that point. And then same thing from 30 to 35. At 35, then they get the remainder of what's in there. So their inheritance is really, as far as them receiving it, spread out over a 10-year period. So even if they screw up that first one, they get a couple more bites at the apple. And hopefully they learn their lessons. And then, at 30 or 35, they're making good choices with the money that they do receive.
And is that trust automatically triggered even if you live a long time, which we all hope and
Sure.
expect?
Yeah. So the neat thing about that is then the trust would still be in place. But because now they're, let's say, 60 years old when we pass away. Well, all of those restrictions about like spreading it out, that doesn't exist
Yeah.
anymore. They hopefully by 6 years old, they figured it out.
Yeah.
And if not, I don't think, spreading it out is really going to help. So, the nice thing about it is you can really protect them while you say, well, we're young and dumb. And hopefully by the time they get a little, older than that inheritance. But the cool thing about it is you can do whatever you want. We've had clients say, I don't want my kids getting anything until they're 50. Use it for them, but they don't get direct control until they're 50. And I'm like, geez, 50. I mean, I feel like you've made a lot of your dumb mistakes before then, but
Yeah.
but ultimately that's what they say.
Well, 50 is the new 25.
There you go. So
So
maybe 50-year-olds are young and dumb still. I don't know. But I've seen people say, hey, we're going to hold it in trust for our kids and then our grandkids and then their grandkids and so on. I have a little bit of an issue with that just because I think, third, fourth generation, if they've, been raised by trust babies who were raised by trust babies, they might be not great people. It's possible that, their parents grew up entitled and now they're raised in these entitled, you may not want it, but ultimately, we just do what our clients tell us. So really kind of, if you can imagine it, what I tell people is whatever you want that inheritance to look like, if you can imagine it, I can probably figure out a legal way of accomplishing it.
Yeah.
I just need to know what you want.
So that's the planning on the front end really does pay off for
course.
generations.
Absolutely.
Now, if you do end up in the probate process, there was no estate plan in place.
Yeah.
And even if there was a basic estate plan in place, wills are still probatable.
Bingo.
So you're still going to probate. Talk me through the process, start to finish, timelines, what it looks like. How often do I have to go to
Oh my
court?
goodness. Okay, I'm trying to see how much time we have here
Mhm.
'cause it's lengthy. What I can tell you is I'll try to break it out into big chunks. So the first piece of it, and there's a lot of filings that have to be done. You're gonna be collecting information about the assets that exist and any potential beneficiaries. It is not a statutory requirement, but for some reason, a lot of the probate courts around the state of Florida are requiring you to file these affidavits of heirs. Basically, they're asking you as the executor to go and figure out everybody who was related to this person that survived them. It's crazy. And so it takes a lot of time, as you might imagine. Um, but so you're gonna have to do that. You're gonna have to find the assets. The lawyer's gonna be preparing all kinds of filings to file. The whole point of that is get the probate open and to get you appointed as the executor. That's what we consider like the opening process. Once you're appointed as the executor, then all your duties start, right? Because now you actually have to start what they call marshal the assets, but basically get all the assets and kind of like pool them together. Make sure you understand where all those things are. Then you have to report to the court where they are. You have to pay off any creditors that exist at that point. At the end, unless it's waived, you have to file a full accounting showing every dime that came in and where every dime went. And then once that's done, then you can finally distribute everything out and close the probate. But that's a very high level view because if we get into the nitty gritty, I'll be talking to you for 30 minutes about it and you'll be asleep.
But the person the executor,
Yeah.
you're not physically doing that work. If you're hiring a firm, you're helping in the process, but
Yeah. So
am I really expected to find my long lost 14th cousin?
Yeah, you are.
Really?
Yeah, because I'm not going to know. I don't know who your family is. And unfortunately, we don't have any tools to really locate that. I mean, you can go to like private investigators or something, they might be able to. But yeah, generally speaking, the executor is the person who has to like gather this data. We simply serve as your liaison as far as an attorney between the courts, but the legwork, that's you. But that's why you get 3% of the assets of the estate, right? So that's what I'm saying. Like it's a job. You are being paid to do a job. You are not being paid to just kind of sit around and let the lawyer handle it.
Wow.
Yeah, it's it is not a undertaking to be taken lightly.
Yeah.
It's a lot of work.
Yeah.
All right, so I guess the overlying message here is to get your estate planning.
Yeah, avoid probate.
Avoid probate.
Because you're gonna put your kids through a lot of time and headache and money. It's expensive.
Maybe for that youngest one, you want them to go through that. It's character building.
Right now, our youngest one, yes.
Oh, man.
Didn't mean to
3
make
years
it
ago,
personal.
Flip.
Yeah.
All right, Jeff, thank you so much. And thank you so much for tuning in today and learning all about this process. If you want to learn more about estate planning, probate, or even Medicaid planning, you can visit our website, fff.law, and we'll see you for the next episode.